Welcome to Inside the Director's Circle and this episode on the power of mediation. I'm Jason Langford-Brown, your host, founder of the Director's Circle, practicing business advisor and coaching psychologist. Conflicts, disputes and disagreements are a frequent challenge for us as leaders, but what do we do when it gets really out of control? How do we take what may seem like a hopeless situation and turn it into a positive outcome? That is what today is all about and how the power of mediation can help. To add some expertise to the subject, we are delighted to welcome one of our knowledge partners from the Circle, Peter Brewer, who is partner and commercial litigator from the national law firm Clark Wilmot and accredited practitioner of mediation. And just very quickly, before we get into the discussion, remember this is just a snapshot of what happens within our business leader community. So if you want to get more involved or access further insights, visit directors-circle.com. So Peter, thank you for joining us. Great to have you.
No problem, pleasure.
And I know you're busy, so I really appreciate you taking the time. So I think just to get right into the conversation and just being mindful that mediation, maybe a word that most people have heard, but not necessarily what it means. So I thought I'd ask you, now, what is mediation and why, for you as a commercial litigator, was it something you wanted to add to your toolbox?
Okay, so as you mentioned, I'm a commercial litigation partner with Clark Wilmot solicitors based out of our Birmingham office. I qualified as a solicitor in 2001, and I think I attended my first mediation probably during my training, so in sort of 2000. So I've got 20 odd years of experience of the mediation process. In 2019, I qualified as a mediator and have started to develop a portfolio of work as a mediator since that qualification. Mediation is a process I've always been a very, very big fan of. It is entirely different to litigation. Litigation is obviously confrontational. It's demanding on the parties. It's also expensive for the parties, both in terms of legal costs, and also, of course, in terms of management downtime. Because if you're liaising with your solicitor, you're focusing on that rather than focusing on developing your business. Mediation, however, is a sort of a consensual, voluntary process where the parties try and meet to reach a compromise position. Now, that doesn't necessarily mean that they in inverted commas win. Inevitably, because it's a process that involves compromise, the parties will probably both walk away dissatisfied. But the important thing is they'll have moved on from their dispute and they'll be able to focus on things that are important to them, namely the development and continued growth of their respective businesses. Or if it's a personal dispute between individuals, the ability for them to move on with their lives without the baggage created by the dispute.
That's interesting, because just listening to you talk about, moving on, I think most people probably do think about disputes, disagreements, conflicts in the context of winning, and litigation, as you said, is a legal process ultimately. So I assume we're often going to court or trying to agree out of court on somebody winning or losing. Is that a barrier for people to even move into the mediation before we even start, that we're just trying to find a resolution to move on rather than actually trying to resolve what's in front of us and me not losing effectively?
I don't think, to give you a sort of a technical lawyer answer to that, the courts very actively expect parties to try and resolve their disputes rather than go off to trial. To the extent that there's a certain stage in the proceedings where you have to return a questionnaire to the court quite early in the proceedings, and that questionnaire asks the advisors specifically whether or not they've advised on mediation and whether or not the parties are prepared to mediate. And there's case law, which I won't go into in detail, it's the wrong forum here, but there is case law that says that if a party unreasonably refuses a request to mediate, then that could actually result in cost sanctions being made against them at the trial. So in terms of encouragement to mediate, there's I suppose the stick element, which is if you don't mediate, you might end up with a cost sanction against you. I think there is also the carrot element as well, which is that it's good for you. You don't want to be locked in now with some of the delays that we see in the court system, potentially 2, maybe even 3 years worth of litigation. If you can resolve things at mediation, then you should do. I think there's another 2 important points really about mediation. First of all, you as the party, you're in control. At trial, you're not in control at all. You can do your best through your solicitors and your barrister, but the person that's in control is the judge. The second thing that's important about mediation is that it's kind of the art of the possible. So if you pursue a piece of litigation, you're pursuing a specified legal remedy. And generally speaking, the courts can't step outside of the remedy you're asking for. Mediation, anything's possible. I, for example, in my time as an advocate of mediation, I've seen people renegotiate contractual terms, restart a contractual relationship, or even consider restarting a business relationship with them. Clearly, those are things that the courts could never possibly order by way of a legal remedy. So it's a much broader process. And really, it's up to the parties to use it to their absolute sort of best and maximum, really.
There's lots of great points in there. I'm just wondering where to go first, but I think we'll go back to some of those points specifically. I'm interested that, I'm already seeing that mediation is an integral part of litigation, whether it's something the courts kind of recommend or require you to early on. And you said you were doing it from almost from the beginning of your career when you were training. So I think I'm curious as to why it took you sort of 18 years to sort of more formalize that skill set. And why after 18 years did you need to formalize it? What was the difference between it just being something you do naturally as a litigator to kind of what you're thinking now?
Well, I think you want to try and define the difference between being a mediation advocate and being a mediator. So as a mediation advocate, you're going into bat for a client. You're there to try and advance their position at mediation, and you're there to advise them on the best, potentially the best way to settle the dispute. But you'll be retained as the solicitor to then take that dispute forward into trial if that's where it goes. The mediator is a very different role. The mediator is there, and we as mediators we receive specialist training from particular mediation houses, the mediator is there to try and help the parties come together, and the mediator sits between the parties. They don't represent anybody. They're there just to help the parties come to a solution. Why did it take me 18 years to train and qualify? Well, I think the first thing is that to have any credibility as a mediator, I think you've also got to have quite a bit of experience. There are mediators from all sorts of backgrounds, but as most mediations take place around a legal dispute, I think it's important to demonstrate some experience in litigation. So I didn't want to do it. I don't want to do it too soon. Also, I've spent a lot of time building what I like to think is a successful litigation practice in Clark Wilmot and in previous firms I've worked for as well. And so that's taken time to establish myself. So it just felt that now was the right time 2019 was the right time to qualify. And my intention now is to spend the next few years developing a decent mediation practice to sit alongside my existing litigation practice. So that's a sort of long-term plan to sort of use it really. And now's the time. I say that because mediation is becoming a much bigger thing. The courts are becoming more encouraging of parties going into mediation, to the extent that the current head of the civil justice system, a guy called Jeffrey Voss, has been talking obviously senior judge in the High Court. He has been talking very loudly about the concept of compulsory mediation in civil disputes. So mediation is a big thing going forward.
Yeah, absolutely. That's an interesting. And I suppose just going back to what you said is clearly it's a different role for you then, depending on how you engage. If you engage as the solicitor versus the mediator, and I think I'm probably just thinking from a business leader's perspective, is there actually a consideration for them whether they choose to go on a legal approach to a dispute, or whether they actually choose to go to a mediator, or is there some kind of blend between the two, or is there a difference at which you make that decision?
Well, I don't think it's not a distinct decision. I don't think. What I would say, by way of someone who's a very experienced litigator, so knows the courts process, I'd like to think pretty well, that mediating soon is the best thing to do. There's bound to be a period where the parties are exchanging some correspondence to sort of tie down their respective positions. But once that's happened, once you understand what the dispute's about, try and get it to mediation as quickly as possible before the costs escalate. I've certainly seen cases, both as an advocate and as a party representative and also as a mediator, where the party left it too long. And the problem there is that the costs then end up being the main thing you'll negotiate over rather than the substance of the dispute. So mediate, identify the dispute. Once you've identified the dispute, then mediate.
Yeah, so it's like, like money gets in the way of the problem almost, or the solution even.
Exactly.
Yeah, it's interesting.
And don't let emotion get in the way. As a commercial litigator or as a mediator mediating commercial disputes, there should really be, and people will feel let down because, say, it's a contractual dispute, one party is let down the other, and they may well have been parties who've had a relationship for a long period of time. But if you recognise that the commercial litigation process is effectively transactional, it's about moving money from point A to point B, just using the litigation process, and therefore take the emotion out of it, you're much more likely to reach a sensible settlement, I think.
And that's really interesting, isn't it? Because I wanted to talk to you about the emotional side, because I really want to explore with you in this particular, because we've got 2 podcasts we're doing with you, and this is the first one. Why is it so powerful? And because the reality is that human beings are emotional. And I know you and I have talked offline about, you come from that world of very transactional legal process, but still realize the power of mediation. And when I think of mediation as a coaching psychologist, I see that as a kind of emotional, psychological journey almost, really. So how do we square that kind of notion of, taking people on almost, you said, take the emotion out of it, actually then you're going to take them on a much more emotional journey in a positive way, I suppose, is what I'm thinking. I'm not sure I've articulated that very well, but I'm just curious on your views on that, just to really get into the heart of why is mediation so powerful?
Well, so one thing it enables the parties to do, which they may never have done since they fell out with each other, is it enables them to sit down face to face and talk honestly and openly about their dispute and how it has actually made them feel. We can talk more in a bit about the process of mediation, but the general proposition, most mediations start with what's called the opening session, which is where the parties sit around a table, the mediator chairs the meeting, and they have an opportunity to present their respective positions. Now, most people would think that the most effective presentations there are done by the lawyers. Actually, I'd argue something else. I'd say the most effective presentations are done by the parties themselves, and very often focused on how they feel let down, how they feel disappointed, those kinds of things that no lawyer can really accurately get across. And I think that can be a very effective way of using the opening session to someone's advantage. Because by the time they come to mediation, it's very likely there's going to be an exchange of correspondence. There may even be a pleaded case. There might have been a case issued at court, in which case everyone knows the law. Everyone knows that one party thinks the other party is legally wrong. So what's the point of repeating that in the mediation? Far better to talk about other things that might influence an outcome.
And it's interesting. So if I just lay in, my own view on that is, as a coaching psychologist, I hear that and go, ultimately the law is ultimately going to lay some kind of judgment. And it may be some prejudgment in the things you just talked about, even that may not be final judgment. But if we were doing conflict in a psychological sense, we would absolutely talk. We'd play into that notion that human beings need to be heard, which is kind of what you're talking about in the opening session. So it's hard.
Yeah,
you've got to remove the judgment and allow people just to be heard and express, as you said, express their emotions. And actually, that doesn't usually get to any resolution, but it gets you to a place where we now got potentially empathy in the room, better understanding, and it's a position to move from, isn't it, really? So it's kind of interesting getting the same approach, the same outcomes from your world and my world, where they're actually doing the same thing, but maybe just slightly different context, maybe.
Yes, I agree with that. I think it's about getting to a sensible starting point, and sometimes talking about feelings in an opening session. So I'm disappointed by what you've done. I feel let down, and I'd like to seek redress. Is probably more likely to get to a workable starting point than someone sitting there saying, you've breached this contract, you've breached clauses A, B, and C, and that's led to me being able to claim rescission and damages, and all that kind of stuff that's already probably been discussed in correspondence and in pleading. So yeah, and again, you see, the only rules in mediation really are be polite, be civil, and be professional. But anything else is possible. So, for example, mediation I did a very, very long time ago between two people who'd established a business together. They'd been in business with each other for some time. we decided that actually the most effective way to a resolution would be to put them together in a room with the mediator. I wasn't the mediator in that case, but with the mediator acting as a referee. But they just let them talk, and that's precisely what they did. And lo and behold, they came out of that room with a settlement, and in fact lamenting the fact they'd even fallen out with each other in the first place. So there are, in mediation, there are no rules, as I say, apart from being civil to each other and being professional. So that's, I think, one of the reasons why it's so effective. It's so flexible, certainly far more flexible than litigation.
Sure, yeah, and I think just probably maybe just going back to why is it more effective? Why is it more powerful? Just generally, and I know there's so many different scenarios here for you, Peter, so it's difficult to answer this sort of black and white. But generally, does mediation lead to some kind of resolution more often, or is it just that the resolutions are more positive for all parties? What's your sense on mediation versus, continually in the legal battle to the end, for want of a better word?
I can't remember the exact statistic, but the Centre for Effective Dispute Resolution, or CEDA, which is one of the big mediation houses, produced statistics based on what on the success of mediation, and they define a successful mediation as being one that settled either on the day or within a week of the mediation taking place. And it's certainly in excess of 85% of matters referred to mediation fall within that success criteria. So, in other words, most cases that go to mediation settle either at the mediation or very, very soon afterwards. As to whether you would define a success necessarily as being a positive outcome for the parties, that's a different matter. A mediator, when you train as a mediator, you have to do some shadow mediations with established mediators. And one of the mediators I shadowed said the definition of a successful mediation is that everyone leaves annoyed. And the reason for that is that one party's had to give more than they want to, and the other party's received less than they wanted to. And very often that can be quite a significant difference compared to what they stated their positions were at the outset of the mediation. But that's the art of compromise. You have to move to be able to get to a final settled position. So would you, if you spoke to someone who's recently had a mediation, would they say it was successful from their point of view? Probably not. That said, I'm yet to encounter a client, either as a solicitor or as a mediator, who said to me 12 months after settling a dispute, I really wish I hadn't settled that. I really wish I continued it to trial and, taken my luck in front of a judge. I think most people, once they settle a dispute, can see the benefit of having resolved it.
Yeah, of course, everybody wants to win, don't they? But I think we all know, any of us in relationships know that actually all successful relationships and outcomes usually require compromise. So even if it's not necessarily what we wanted on a personal level. So I think that tells a big story. I think what you described to me was win-win, but not quite in a slightly different context. It's we both lost a little bit, lose in a small enough way that it wasn't too painful. Exactly. Yeah, absolutely. I love the compromise.
So you win back the opportunity, or the opportunity cost of not deploying capital in your business, but instead spending it on legal fees. You also win back your own time, because, like I say, taking the witness statement phase in a dispute, for as an example, the way that the court rules work now is that if I want to take a witness statement from you, I have to come and meet you. I have to sit down and take a witness statement on a laptop. We then would have to run it past you 2 or 3 times whilst you amend it. It has to be in your words as well. There's specific rules around that. So the witness statement phase of a piece of litigation is now very client heavy. It's very client centric, and that's extremely time consuming. A witness statement might take a week or maybe more than a week's worth of a director's time away from their business, and that's not healthy for the business. That's a diversion of attention that ought to be focused on what the director or the senior leader is doing in their day job, not in dealing with the dispute. So that there is a real, when a case settles, we are giving back time to the people that were involved in the dispute, and which they can then deploy much more usefully elsewhere.
And I was listening to, I think that the 2 big things I'm getting from here, the mediation gives you, massively mitigates how much money you spend, but also gives you that huge amounts of time. So the whole thing for me is the resetting of what the value is and getting to some kind of compromise effectively, not just winning. People go in thinking I need to win, but actually what they should be thinking about is how can I get my time back? How can I mitigate how much money I spend on this so I can be doing it, like as you said, move on my life and do the things I want to do? And I just wanted, I mean, just taking that point, you know, and I'm sure people listening to this now are thinking, and we should be doing more mediation to get through things more quickly. I love that statement about 85% get to a resolution, but it was the speed at which they get there, I think, is the powerful point of that for me. But I'm just thinking, if I now take, you know, from this, they'll go away and go, okay, we just need to mediate at all costs. Thinking about that complement between the legal process and mediation, if I start, you know, and I know we're all guilty of this, we find a better way and then we'll just ignore the legal side and just go, let's just mediate. What's the risk for me as a leader if I almost ignore the legal process and just mediate on its own?
Well, I think the mediation is probably complementary to the legal process. It's very likely that a dispute will start. First of all, by the parties falling out with each other over a legal issue, so a breach of contract or a breach in a relationship between two directors, and they will go and see solicitors to try and assist them with that fallout. That will then lead probably to some correspondence being exchanged between the parties, usually through their solicitors, which will set out the parties' respective positions. There will come a stage when it's obvious that they ought to mediate. And I'd suggest that those stages are either once you've exchanged all your correspondence and therefore you understand what the case is about and you understand what the dispute is, what the issues are, and therefore immediately you issue proceedings, or once you've issued proceedings and you've exchanged your pleadings for a particular claim of defence, a reply to defence, those formal documents that you lodge at court to set out your case. And then you should mediate at around either of those two stages. Any later, you know, once the case moves beyond the pleadings and you end up in case management, where you're having to do disclosure, you're having to do witness statements, you're having to engage an expert to give an opinion, you're having to then prepare for trial. As you get into those later phases of the case, mediation at that stage, I think becomes less effective, because by that stage, the costs are an issue. And the parties are now in the fight mindset rather than the compromise mindset, because they're so close to trial. So I think that the sooner the better, but probably at some stage after you've exchanged sufficient information to actually understand what each other's cases are.
Yeah, and I've heard that a few times through this conversation, that legal bit just feels to get real clarity on what the real dispute is. And I think that is important, that we're all on the same page of where we are now, almost really. I think probably, though, you've said it so many times, I suppose the question that's on the tip of my tongue is, you know, why don't, you know, how many people don't mediate at all or mediate too late? And what is it? What's the most common reasons for them doing that?
I would say so. One. I mean, there's probably no statistic on this, and you accept as well as a lawyer, there are certain cases that absolutely have to go to trial because they're not capable of being settled for whatever reason. So for example, if you're seeking a declaration at court in relation to, I don't know, the convening of a board meeting, there's no way to settle that. That's either one thing or another, isn't it? You either are going to get the declaration from the court or you're not. There's no way of having a halfway house between those two things. So that kind of case has to go to court. I think that people that are mediating late, sometimes it's because they just don't feel they want to mediate, and they might have adopted an unreasonable position. It might be because there's not been sufficient exchange of information during the litigation process to enable a party to mediate. So a prime example of that might be around the provision of sufficient information to value an asset, if there's an asset in dispute. You would need possibly some expert evidence to tie down that valuation, and that may take some time to obtain. But I have ringing in my mind, as I said earlier, the fact that the courts take quite a strict view in relation to people that don't mediate either at the right time or at all, and that there is the possibility that the court might say you should have mediated either A, at all, or B, earlier. And that in not doing so, you've litigated unreasonably, and that can expose you to a cost order as a result. So you know, it's difficult to say why people don't mediate, but you know, I think any sensible solicitor representing a party would advise A, to mediate, and B, to do so quickly.
Yeah, Peter, so many good points in there. I mean, I loved some of the things you talked about, in terms of, it's about getting to a compromise so you can move on with your life. It's about resolution so you can move on. I love that reframing of, getting your time back and mitigating, the cost that you can waste in the litigation process when you could be, mediating. And I love this notion that it actually does give you some control, and it opens up the art of the possible. But just to give you the last word for today, just maybe the top three reasons for you why people should really open their minds to mediation.
I think because it's effective, it's a good process. I think also it avoids the unnecessary risk of taking a case to trial and leaving it to the judge to decide. The judge will be a person you've never met before. You don't know them. You don't know what their belief system is. You don't know what their background is. Also, I've certainly taken cases to trial that I expected to lose and have won, and expected to win and have lost. And there can be all sorts of factors behind that. The most important one will be the performance of a witness, which you have absolutely no control of. So the trial process represents a complete handover of control of your dispute from you and your advisors to a judge who you've never met before. And that's a risk. There's not many things in my life where I would give someone I've never met before complete control over something. And I think, like I've mentioned, the economy, or the economies of the process. Mediation is a significantly cheaper process than litigation, and I think that's an important thing for parties to bear in mind, to try and get things resolved so that they can move on.
Wonderful, Peter. Thank you so much for your comments. There was some great stuff in there that I'm sure our listeners will pick up on. And next episode, we're going to have Peter back again, and we're going to. And there was a few things that Peter picked up on that I'm really going to get into the next episode, which is, I think when exactly and how to use mediation. And Peter did allude to, the how mediation works. And we'll definitely get into that. We'll look at the circumstances, some of the professional support that's available, and hopefully a few more practical tips for you as a leader. But in the meantime, if you want more information on this subject, you can reach out to us at the directors-circle.com. Peter's always available. I'm sure you can find him on LinkedIn. But in the meantime, thank you for listening to Inside the Directors Circle.